In this video, we're going to be discussing 10 of the more egregious statements made by the prosecution during the trial of Lucy Letby. I should qualify this by stating that I could call this video the 10 most egregious statements, but I can't say with any confidence that these are the 10 most egregious statements. It's difficult to remember considering the entire prosecution case was egregious, but I wanted to highlight these 10 things in particular so that people can see just how ridiculous some of the things and how unfair and how unreasonable and how without foundation some of the things said in court were. So I want to be clear that this is information that was disseminated by the prosecutor, almost always Nick Johnson, KC, not this gentleman. This gentleman said plenty of ridiculous things in court, and has said ridiculous things since then, but these are not specifically related to the prosecution. Realistically, he represented the prosecution in court, but this isn't about the scientific evidence. It's not about Dr. Dowie Evans. This is about statements made by the prosecution in the prosecution of Lucy Letby. So we see there Nick Johnson, KC, on the screen. I should say that this is what Nick Johnson, KC, actually looks like. So this, in my defence, that is perhaps why I didn't recognise him in another video and I put a picture of a wrong person up on the screen, because I think the court artist has been rather flattering to Mr. Johnson there, who actually looks like that. I know he's got a wig on there, but it looks absolutely nothing like what he looks like in real life, in my estimation. So I would like to defend myself in that way. But most of the comments here, I believe, in fact, all of the comments we're going to be looking at in this video were made by Nick Johnson, and they're all related to the prosecution rather than being scientific evidence or scientific information that was presented in court. So the first of these issues is the swipe card farce. Now, it's fair to say that the swipe card data was pretty shaky to begin with, considering that it's reversed, as is now infamously known to be the case, and this relates to 9 infants in the case. So already the swipe card case is pretty bad. On top of that, there's the issue with the staircase that led into the nursery that didn't have a swipe card entrance. And also, what people perhaps don't know is that the swipe card data was never intended to track staff in the first place. But I'm not going to get into all these issues in this video. I just want to talk about one exchange that occurred in court. This is when Nick Johnson, Casey, said to Lucy Letby, "Did you go into neonatal unit late at night when you weren't on shift?" And Lucy Letby replied, "I would sometimes go when not on shift, sometimes to finish paperwork." Johnson asked, "So there are times when you've been on the neonatal unit when there is no trace of you having been there?" And Lucy Letby says, "There would be a trace because I would have had to swipe. There's no other way." And then in response to this, Nick Johnson says something pretty extraordinary. He says, "Swipe data doesn't always show when she was there because colleagues could have held the door open for her." So that, of course, applies to swipe card data throughout the entirety of the court case. And anyway, I'm sure people watching this video have worked in an office with swipe cards. I have previously. I'm pretty certain that I didn't always swipe my card every single time I went somewhere. Obviously, this is the kind of thing that happens in workplaces all the time. And I've spoken to numerous nurses, and they've all said, of course, people sneaking behind each other all the time. This is actually what Johnson is saying here is true. It's not that what he's saying is untrue. What the significant issue is, this swipe card data, despite a lot of it being reversed, despite the staircase, despite other problems, and now despite the fact that we know that it's pretty obvious anyway that this data isn't necessarily accurate because people can sneak in behind each other without swiping their cards, as he's stated here. But yet, all the way through the rest of the court case, the prosecution relies on swipe card data. So there's a statement here from the Crown Prosecution Service in which they said, "We have been transparent in clarifying this issue and rectified it for the retrial. We are confident that this issue did not have a meaningful impact on the prosecution, which included multiple strands of evidence." So that's the Crown Prosecution Service attempting to defend the fact that swipe card data has been reversed. Since it was revealed that it's been reversed for 9 infants, they haven't said a single thing, which is not surprising. But essentially, they're just trying to downplay the significance of this. Oh, we're confident the issue did not have a meaningful impact on the prosecution, which included multiple strands of evidence. So that requires you to reach into the minds of the jurors and engage in some process of mind reading in order to ascertain whether or not it had an impact on their opinion. It's just simply impossible, obviously. And then in addition to that, the important thing to note is it's reasonable for the Crown Prosecution to say that there are multiple strands of evidence, but the swipe card data is used all the way through the court case to tie everything together. So with some very basic digging that took a matter of a few minutes, this is not an authoritative record of all the times that swipe card data was mentioned in the court case. It's just a very brief piece of research that I've done. But at the very least, in 2022, is mentioned on 16th of May, 18th of May, 7th of June, 11th of October, 17th of October, 18th of October, 20th of October, 21st of October, 3rd of November, and 11th of November. In 2023, it was mentioned on 2nd of February, 10th of February, 27th of February, 28th of February, 5th of May, 16th of May, 17th of May, 18th of May, 8th of June, 20th of June, 26th of June, 30th of June, 5th of July, 6th of July, and 21st of August. And then in 2024, it was referenced repeatedly throughout the entirety of the retrial related to Child K. I also managed to ascertain it was mentioned in relation to Child A, Child B, Child D, Child E, Child G, Child H, Child I, Child J, Child L, Child M, Child N, Child O, and Child Q. I should say it wasn't mentioned in relation to Child F because Lucy Letby wasn't there, so it couldn't be used as relevant evidence. And of course, as I've just mentioned, it was absolutely instrumental in the case of Child K, and literally the entire prosecution case had to be changed for the 2024 retrial because it no longer made any sense whatsoever. Now, we know what people who are determined to believe that Lucy Letby is guilty will say. That wasn't important evidence in the prosecution case. That's what they always say. So the second issue I've referred to here is the fabricated monitor incident. Now, I want to go over this as quickly as possible because I've dealt with it in depth in the video that I've made related to Child G. But this involves Dr. John Gibbs and Dr. David Harkness failing to recall incidents related to a monitor on the unit. The critical aspect of this is that a nurse gave testimony in court indicating that Dr. Gibbs had apologised to her, and it says, as is stated here, the nurse refuted any suggestion Miss Letby had turned off the monitor and said consultant paediatricians Dr. Gibbs and Dr. David Harkness had apologised to her for not switching the monitor back on after fitting the cannula. She'd seen Letby responding appropriately and using a resuscitator on the infant and simply noticed the monitor had been switched off, which was not normal protocol. I should also be noted here that Lucy Letby shouted for help from the nursery where Child G was being cared for. This is just a reiteration that the two doctors, Dr. Gibbs and Dr. Harkness, had approached this nurse the same afternoon to apologise for leaving Child G behind the screen and for not turning the monitor back on after completing their procedure. Dr. Gibbs conceded that he couldn't remember the events the 21st of September and said that if the nurse had made those comments, presumably that's what happened. And then he made some other comments about the monitor, and then he just repeatedly said he couldn't remember what happened, agreed it would be a serious error to leave a baby in such circumstances. He agreed that he could have been called to another emergency and may have been forced to leave Child G in a rush, but said he could not remember. So the only tangible evidence in relation to this incident comes from the nurse, who is critical of Dr. Gibbs and Dr. Harkness, which they can't remember at all, and defends the conduct of Lucy Letby. It's only the prosecution that states, with absolutely no evidence whatsoever, that Lucy Letby has done this, and it is completely fabricated. It's without any evidential foundation whatsoever, and it twists on its head the only evidence that is actually available. So I would consider that to be, although it's a relatively minor issue within the court case, and it only relates to one infant and it's just one part of that, there's much, much worse evidence in relation to Child G. But this is nevertheless a significant moment where the prosecution have just simply, I don't think you can even say this is supposition, this is pure fabrication, which I think is indefensible, frankly. Number 3, we say you should do the opposite of your training. So this refers to incidences in court where, as is reported here, it was suggested that Lucy Letby was standing around doing nothing. In this particular case, the hospital consultant in question is Dr. Ravi Jairam, but there were other instances in which the prosecution said exactly the same thing. Now, I've spoken to several neonatal nurses, including one who worked at the Council of Chester, and they all say exactly the same thing, that you should have a period of observation where you monitor the infant to see what is occurring exactly. And this was standard operating procedure at the Council of Chester, and more broadly, it'd be standard operating procedure with regard to neonates generally. It may apply full stop to babies of all gestation periods, but this is an account of a nurse, Mary Griffiths, in court, who's explaining about neonates. And she says, with regard to neonates, they are just so fragile, so you need to monitor them constantly. So that is literally what Lucy Letby was doing. She realised there was an incident and she realised there was a situation occurring. So she was monitoring the infant to decipher what the situation was and whether intervention was required, which is literally exactly what you're supposed to do. Mr. Myers says a desaturation is not uncommon in a neonate. Miss Griffiths agrees and agrees that such desaturations can happen within seconds. She adds that what's been described by the prosecution and bizarrely described by consultants on the unit as standing around doing nothing is instead a hands-off technique for such neonates, as handling them could cause stress, and that is why they have electric monitors. It was also explained to me that it's very easy to introduce infection into a neonate, so you don't go reaching into the incubator unless there's a very good reason. And then Mary Griffiths goes on to say a nurse should wait to see if a baby self-corrects when it desaturates, paying attention to the skin colour of the baby as an additional observation, and only then, if the situation does not resolve, an intervention will become necessary. Now, when the prosecution was dealing with this, they asserted that the only reasonable thing for Lucy Letby to do was to intervene immediately, and that they obviously stated explicitly and implied as well that she was doing nothing, and the reason she was doing nothing was because she wanted the baby to die, which is, frankly, not only is it an outrageous accusation that's unfounded, as so much of this prosecution case is, but also it goes directly against what she's supposed to do in that situation. This is established by neonatal nurses. It's been stated in court. It is known to be the case. It is known that what prosecutor Nick Johnson is saying here is factually incorrect. But they just said it anyway. And in a complicated court case in which all these comments pass by so quickly, the jury has to listen to 10 months of evidence, and they don't know the first thing about neonatal nursing. They can very quickly get a wrong impression. And of course, I've heard people say, oh, she was just stood around doing nothing. I've seen people saying that on YouTube. I've seen people saying it in comment sections of newspapers. I've seen people saying it on social media. But in actual fact, what she was doing was monitoring the infant to check whether or not there was a deterioration, to check whether intervention was necessary. If she'd have gone straight there, reached into the incubator, then that should be held against her because she would have been doing the wrong thing. So what the prosecution is doing here is admonishing her for doing her job correctly. Number 4, Lucy is wrong to do her job. So this refers to an incident in relation to child O, where the prosecution was advancing this absurd and completely unsupported theory that she was infatuated with a doctor on the unit. So in the case of child O, Lucy had called this registrar, I believe it was a registrar on the unit, but certainly a doctor. No, what is correct, it was a registrar, which is a type of doctor, of course. So she called this registrar because there was a deterioration in the state of child O. And we had this remarkable exchange where Johnson said, were you trying to get his attention? Yes, I wanted him to help. But his personal attention? No, he was the registrar on the unit that day. Did you enjoy being in these crisis situations? No. So here, the prosecutor is suggesting that Lucy Letby was wrong or had some sort of ulterior motive for attracting the attention of a doctor to a medical emergency on a neonatal unit, which I think is frankly disgusting and disgraceful, and I won't make any further comment about it other than that. Item number 5 is Pyjama-Gate. Now, people that are familiar with this case will know exactly what I'm going to reference here. Those that aren't familiar with it may find this quite surreal, which of course it is. But at some point during the proceedings, Ben Myers cross-examined Lucy Letby and was discussing her arrest. So I'll just read this section to you. Are you able to just describe in simple terms the impact of your arrest and that process on you? Let me start with this. How did you know the police were coming that day? What's the first you knew? When there was a loud knocking at the door at 6 o'clock in the morning by the police. You were at home in 41 Westburn Road, Chester, is that right? I was, yes. Were you on your own there as it happens? No, my father was staying with me at that point, so he was there as well. Had you any idea the police were coming that day? No, none at all. So when they came, what happened with you? They told me that I was being arrested for multiple counts of murder and attempted murder, and then they quickly handcuffed me and took me away. All right, and you were taken to a police station, is that right? In my pyjamas, yes. And over the next 3 days, you were interviewed at various times, yes. So you'd hardly think from that account that the pyjamas were particularly significant. But then later on, Nick Johnson was cross-examining Lucy Letby, and this exchange occurred. You are a very calculating woman, aren't you, Lucy Letby? No. You tell lies deliberately, don't you? No. And the reason you tell lies is to try to get sympathy from people, isn't it? No. You try to get attention from people, don't you? No. In killing these children, you got quite a lot of attention, didn't you? No. In killing these children, you got quite a lot of attention, didn't you? I didn't kill the children. So that's the repetition. And you're getting quite a lot of attention now, aren't you? On the third arrest, you left the house in a pink or salmon pink coloured Gap leisure suit, didn't you? I can't recall. Again, I don't know. You weren't in your pyjamas, were you? No. So to go over the whole thing takes some time. There's a brilliant and very detailed post about this on Reddit about how the cross-examination that Johnson here is trying to confuse her in cross-examination. But I'll just read this briefly. It's just mentioned here that Johnson does not dwell on the fact that during the second arrest she also asked for and put on a dressing gown over the tracksuit, and for good reason. The fact that she bought a dressing gown with her makes it clear that whatever she was thinking as she chose her clothing, she was not thinking in terms of putting on normal outdoor wear. Few people go out for the day, whether it's to a high-rise office or just the grocery store, with a dressing gown as the finishing touch to their outfit. But she did. Why? He doesn't ask. He simply continues to hammer her about the fact that she referred to a tracksuit as pyjamas, now insisting that she lied to the jury when she initially told the story of her arrest to Myers. Of course, not only is this an incredibly trivial issue, but they couldn't establish anything of significance that she'd lied about. There was a couple of things that I'll go into at some point during the court case. The idea that she lied about these things has already been completely discredited. This was the closest they could get to saying Lucy Letby lied, discussing her pyjamas. So 3 things to say about this is that firstly, Lucy did not state that she was wearing pyjamas to elicit sympathy. By far the most important part of this story was that she was woken up at 6 a.m. handcuffed, arrested and accused of multiple murders, none of which is contested. Secondly, it is highly debatable whether what she said was inaccurate anyway, but it's certainly not a deliberate untruth. Thirdly, this line of inquiry clearly has no merit anyway. The prosecution is simply using underhand tactics to brand Lucy as a liar. So we see this reporting of the time. Nurse Lucy Letby has deliberately misled the jury on a number of occasions throughout her murder trial, a prosecutor has told the court. On the final day of cross-examination, prosecutor Nick Johnson KC said Miss Letby was a very calculating woman who had lied to try and get sympathy. Now, for them to accuse her of deliberately misleading the jury when the prosecution has, on several occasions, literally fabricated evidence and engaged in supposition which it cannot provide any evidence for and for which there is no support on countless occasions, it's pretty rich of them to accuse Lucy herself of deliberately misleading the jury. Large swathes of the prosecution cases we've just seen with regard to the swipe card data is, I would say, deliberately misleading. So you may think, right, well, no serious person is going to be convinced by that or be convinced that she's lying. You know, it's all a load of rubbish. But this is an exchange from one of the podcasts made for the Daily Mail. So here we see Spectator A saying, I found her to be deeply, deeply dishonest in some of the answers she gave. Spectator B, Go Commando was the one for me. I don't know what Go Commando is. We'll come back to that in a minute. Spectator C, I do know, but I didn't at the time. Spectator B, oh well, bless you, Mary. Spectator A, I'm still proud of myself for not bursting out laughing during that particular exchange. The final day of the cross-examination that Friday, that was particularly damning, I thought, in terms of just ripping apart a whole tissue of lies about being isolated from colleagues. We're going to come back to that in a second. Not being allowed to socialise with them. That social life dossier. Even just down to silly things around, oh, I was taken out of the house in my pyjamas and it was actually a Lee Cooper leisure suit, Nick Johnson called it, a tracksuit. Well, we saw that on the arrest video. So from listening to her in court, I just found her to be someone who's a compulsive liar. So that's how easy it is to pull the wool over the eyes of the average person. That is how stupid people can be. Don't underestimate the stupidity of people. Never underestimate that, because they'll always surprise you. So there's a reason they're doing this in court. There's a reason they dragged out so many eyewitnesses. It's always to try and firstly make it into an emotional case with the eyewitnesses, and then secondly to discredit the witness and to put the germ of an idea in the minds of jurors that she's unreliable, that she's lying, when the vast majority of what she said during her account is undeniably true. They pick one small detail to try to muck around with it in order to suggest that she's lying, which she wasn't lying, because she wore a dressing gown outside of the clothes that she slept in. Whether or not it's reasonable to describe them as pajamas or a leisure suit, it's just, I mean, at best it's semantics. That's being generous to describe it as semantics. So that's a fifth incident, really, of the prosecution engaging in a ridiculous, from any kind of objective measure, a ridiculous line of questioning and a ridiculous series of assertions that, in my estimation, is just a complete fabrication. But that wasn't the only time where they discussed something completely trivial. Number 6 is Shredder-Gate. Now, the Shredder and Pyjama incidents are almost indelibly associated with one another now, even though they're separate, I would say, just because of the sheer absurdity of the two incidents. So you see a comment from the Time here. This is in Sky News. Lucy stating that she couldn't destroy the confidential notes, but jurors were told that she had a paper shredder in her home. So the implication then from that was that she'd lied about not having a shredder. It's important to remember she has been through a few relatively important life events at this point, such as being arrested 3 times, interviewed by the police for 24 hours, literally 24 hours of interviews, 23 hours, 48 minutes, I believe. Being incarcerated, being denied bail, being held for 2 years, having a breakdown, going through. It's possible that she'd forgotten about the shredder. I don't know. I mean, it could be a web of lies that she's weaving around the shredder, but I think more likely that she simply just forgot that she had one. And then in addition to that, I've written in my book here, when it was proposed in court that she had lied about this, Letby responded not unreasonably that she hadn't recalled this because it wasn't a significant item in her house. Like the pieces of paper, Nick Johnson retorted. Yes, Nick, the piece of paper that she could have shredded with a shredder if she wanted to cover up this evidence. Of course, the reason she didn't shred these pieces of paper, that are not part of this video, but we'll definitely do a video on the anecdotal evidence at some point, is because she never considered them to be significant. You can actually see this in police interviews at the time where she can't even recall them. And she could have just used a shredder. She could have shredded. Basically, the police, if she'd have used a shredder, the police would have recovered literally no evidence for this case, because everything they had, I suppose they could have tried to use the text messages still, even though there's nothing in the text messages, or they could have tried to use the Facebook searches, I suppose. But seeing as that's all supposed to be based on this brilliant pattern that they came up with that they've never specified, and then they pretty much dropped it now because it's plainly ridiculous. The police would have recovered almost nothing. They just would have had electronic communication. So their contribution to this case, after 5 years of investigation, would have been the Facebook searches and the text messages if they put them in the court case. She could have just shredded the paper evidence if she thought, if she felt guilty, if she thought it was significant, if she committed any crime, she could have gone through her whole house shredding everything. But of course that didn't happen because she doesn't consider herself to be guilty, because she knows she's not guilty. She doesn't consider this to be significant evidence because she knows that it's not significant evidence, so consequently, she didn't shred any of it. Number 7. The truth is that we don't have any evidence for this. So this relates to a statement that was made by Nick Johnson during one instance of summing up, where he said, "The truth is, ladies and gentlemen, that Lucy Letby had a fascination with the babies she had murdered and attempted to murder and with their families. She took pleasure in her murderous handiwork." Now, I'm sure you get all kinds of bombastic statements being made in court cases that are untrue, but I think particularly to describe this as the truth when there is literally zero supporting evidence for this is pretty fanciful. Particularly the assertion that she took pleasure in her murderous handiwork, for which there is no evidence whatsoever. So there was no evidence. The police have absolutely rifled through everything that she's ever written, everything she's ever texted to anyone, anything that she's done online. They've excavated her entire life. There's no evidence of even referencing any murders, let alone that she took pleasure in them. There's nothing from her demeanour that was considered unusual. So the nurses all spoke very fondly of her, as we've seen in previous videos. And she, as is stated here, she sobbed in court. She sobbed during the police interview. She was known to sob on the unit. Catherine DeBager has said she was very emotional and very upset during her counselling sessions. Karen Reese would say she was very emotional about things in an appropriate and normal way. There's just absolutely no evidence whatsoever to suggest that she took pleasure in her so-called murderous handiwork. I might as well say prosecutor Nick Johnson. Let me phrase it the way he phrased it. The truth is, ladies and gentlemen, that prosecutor Nick Johnson enjoys flinging cats into rivers in his spare time. Obviously, I don't believe that. It's categorically untrue. But I have as much evidence for that as he has for what he's asserted. But he's described what he said as the truth, and he stood up in a trial, in a court case, and said, "This is the truth." The only thing to prevent it from being the truth is we don't have any supporting evidence for that whatsoever. Number 8, lying about Lucy's friends. So this was another incident that occurred in court in which Nick Johnson accused Lucy of lying about being cut off and isolated from friends on the neonatal unit. And it's clear she had quite close friends. As we've seen in the previous video, some of them stood by her, some of them explicitly stated they were friends of hers at the time. She obviously invested a lot of energy into her job. A job and a profession were essentially her life. And then she was cut off from them and was told not to contact anyone in the unit. In response to this, Nick Johnson accused her of telling a sob story, the implication being that it's untrue. And we see in reporting the time here, on the final day of cross-examination, Letby was accused of deliberately misleading jurors with a sob story over her removal from the job she said she loved. However, in February 2025, in this Rule 9 questionnaire response of Claire Bevan, INQ0101068, this is yet another document that the Thirlwell inquiry suppressed until February 2025, after the public inquiry was over. What did Claire Bevan say? "I was not aware of concerns of others until Letby was removed from the neonatal unit and relocated to another area of the hospital. Letby and we were told not to have any contact." So she's explicitly corroborated what Lucy Letby said, and she has explicitly corroborated that Lucy Letby was telling the truth. That didn't stop Nick Johnson prosecuting from accusing her of being a liar about something that is demonstrably, explicitly, undeniably true. Number 9, do you remember being born? So at some point during the court case, there was this discussion between Nick Johnson and Lucy Letby. Do you dispute you were in the room at the time of the collapse? Yes, because I have no memory of that. Do you remember being born? No. Do you dispute being born? No. I would say this requires no further comment, but I suppose it's just worth mentioning that absolutely no one remembers themselves being born, although maybe it's possible that you might get 0.00001% of people that can have some memory of it, and it can be recounted through hypnosis or something. But I've never encountered anyone in my life who has an explicit memory of being born. So the implication here is that her version of events is not reliable because she can't remember herself being born. But if you're going to take that to its natural conclusion, there's no point asking anyone anything in court because No one can remember themselves being born. I mean, this must be considered possibly the most egregious exchange, because this gentleman was paid hundreds of thousands of pounds to work on this case, probably. I shudder to think how much money he's made from being involved. I'm sure that it will be more than, for example, the average house price in Britain. There's people all over the country, young people in particular, struggling to, move out of their parents' home because of the inflated price of housing. This guy just got paid astronomical amounts of money to stand there saying, "Do you remember being born?" It's embarrassing. It's embarrassing. It does make me angry because I try and keep as level-headed as possible when thinking about this and when doing these videos. But come on, we're all adults. How can this be? How can this be in a court case of this magnitude involving adults, where someone can be locked away for life sentence after life sentence with no hope of parole, and he's there going, "Do you remember being born?" It's just farcical, embarrassing, ridiculous, disgusting. Number 10, outright misogyny going commando. So this was referenced earlier in the video, and I'm not going to go through the whole exchange in relation to this, but essentially, Nick Johnson prosecuting, there was a text message from a colleague, which is just a kind of teasing text message saying that Lucy was going to go commando. And it seems quite clear there's no romance with his registrar at all. It's probably him that's far more interested in her than vice versa if you actually assess it. And there's certainly no concrete evidence of any even meaningful flirtation between them, let alone a romance or affair or anything like that. But there's this one throwaway remark of going commando. Nick Johnson made a big deal out of it because it was part of the prosecution narrative. And essentially, he tried to humiliate Lucy Letby in court. I'm sure people watching are aware that go commando means, it's from a joke in Friends, the sitcom from the 90s. It just means to not wear any pants. And it's quite clear that Lucy was embarrassed by this, and he tried to make a big deal out of it, and she didn't want to discuss it. And she tried to explain it away by saying she didn't know what it meant. She probably did know what it meant. But he was trying to make a big deal out of it, when obviously it's quite an embarrassing thing, I would say, for a woman to be in a public place with everyone staring at her. She might be slightly shy, and then to try and make her say, "Oh, the nurse was implying that I would go pantyless so that the doctor could have sex with me." That could be quite embarrassing for someone to have to recount, really. And it really has no relevance to the case whatsoever, and yet there was quite an extended period where Mr. Johnson decided that he would go to town on Lucy on this topic. Now, in my book, I've written that the stench of classism and the distinct whiff of misogyny is never far away from this case, and I would absolutely stand by those comments. I think the classism is a more important factor, but I do think there is a definite misogyny involved in this case as well, and I know some people that I really respect have posted videos about this online and explain this in much more detail than I've gone into. I think the reasons for this are quite clear. It's essentially male consultant doctors being believed over female nurses. And that's particularly tangible in the case of Child K, where the account of Dr. Ravi Jayram is so unreliable it's completely laughable. And yet he's still believed over 3 nurses that all contradicted his account of events. And I can't see any other reason for that other than just simple classism. And I do think there's a definite element of misogyny. And certainly in court, Nick Johnson had no problem with completely humiliating Lucy Letby with regard to this underwear issue. And clearly that has no merit as to whether or not she murdered babies on the unit. And yet he really laboured the point in a way that I think was pretty distasteful. So that's all the 10 points I want to raise. I just want to say that, as an honourable mention, I could have made a point about Datix that was used in the case, where it was Lucy Letby was accused of covering things up, lying about things, etc., when in fact all the evidence points to her being the most conscientious completer of Datix information on the unit. This is the notes system that is used internally in hospitals. I've actually had a nurse examine all the Datix data that's available from the Thirl Inquiry, and she has examined all this as a qualified neonatal nurse and explained to me all the evidence points to Lucy being the most conscientious person on the unit, and that's clear anyway. In the comments of her employer, in the comments of her manager, in the comments of the nurses on the unit, very explicit comments that were made. But I didn't go into that because it's quite complicated and it would have taken quite a long time. So those are 10 examples. I don't say they're the most egregious examples, but they're certainly some of the more egregious examples of things that were said by the prosecution in this horrible court case that has produced this really blatant miscarriage of justice of this quite obviously innocent woman. And I don't know what goes on in court cases generally. It's obviously very difficult to ascertain because it's difficult to get the transcripts. We don't record court cases in this country. I think one thing that should come out of it, this whole grisly business, is that we should very seriously consider recording all police interviews and recording all court cases. I would certainly be an advocate of that because then we'd have everything on the record. Dr. Evans wouldn't be able to say, "Oh, you don't know what happened in court." We do now, but we would have known immediately, and he could never say that. Actually, it's been useful in a way because he's come out and said a load of things that are ridiculous, but we simply would have known from day one what he'd said in court. It would all be recorded. We wouldn't be relying on piecing it together from transcripts and court reporting and other things. So I think that's a very important thing going forward. But aside from that, please let me know what you think of this video in the comments. If you have any queries or questions, that they're always very much appreciated. I try to answer as many comments as I can, and I read everything. The last thing is I always like to plead for subscribers at this point. It's definitely going up steadily, and I'm really appreciative to everyone that's subscribed. But I've been trying to do YouTube properly. I mean, I didn't know I was going to become a proper YouTuber. I just thought I was going to make one video and then stop. But I've realised I can do quite a bit, and people seem to be enjoying them. So as long as they are, I'll keep doing it. So I've learned a few things. I learned how to do a couple of things I didn't know how to do, and then I was trying to format the last video in a way that made it work better for the algorithms. So I'm getting there steadily. But when I read about what you're supposed to do on YouTube, they're always saying encourage people to subscribe, like, etc., because the algorithms require this. So I will be boring and say this again. But yeah, thank you for all the support. If you do have any comments, they are very much appreciated, and I really appreciate people watching the videos and interacting.